All right, good afternoon, everyone. I want to welcome you to the CLE event on the Dobbs opinion. We'll be hearing from Professor Emily Berman today and in a conversation with Barbara Dosky. And I just want to get a few announcements out of the way. So next month, Thursday, August 4th, we're going to be having another CLE free. It's going to be about gun control with Representative Rosenthal and some other speakers about gun safety in Texas after Uvalde. Another announcement, the Harris County Democratic Party is hosting the 2022 Coordinated Campaign Volunteer Kickoff event tonight at Axelrod from 7 to 9. So if you have a few minutes to join them, it's free tonight, Axelrod. And last, let me introduce myself. I apologize. I'm Carly Miller, the president of the Democratic Law Students Association. And we have been kicking off a few new chapters of student-run organizations at every law school that connects democratically minded individuals with mentors in the community. So if you want to be a mentor to a progressively minded law student, we are accepting mentors. And I will just, if you want to be a mentor, here is the link to a form. So if you could just fill that out. Also, if you know any law students at U of H or Thurgood or UT that want to start a chapter of a Democratic Law Student Association, let them connect with me. I'll put my information in the chat, and we can help them get started. So one last reminder, in September, we will have an in-person CLE talking about the world of economics with world-renowned economist Ray Perryman. He's going to talk about state and national issues that the country is facing that bring solutions that incorporate corporate America. So if you're interested in that, I know we have a lot of private corporate lawyers here, so join us in September. And without further delay, here is Rose Clouston, the Director of Voter Protection for Democratic Party.
Hey y'all, thank you so much for joining us today. Thrilled to be with you and talking about this very timely and important topic. As Carly mentioned, this CLE is hosted by the Harris County Democratic Lawyers Association, and we are so grateful to them. And it is joined and invited to all of you, but also with in conjunction with the Texas Democratic Lawyers Association. For those of you who are, maybe this is your first CLE with us or first event with us, the Texas Democratic Lawyers Association and the local chapters, including HCDLA, provide timely CLEs like today's, as well as community and service opportunities for the legal community in Texas that aligns with our values, so that folks have those opportunities and can do great work and use your legal skills in ways that also serve your community. A couple of upcoming opportunities that I wanted to share with you before we get into the meat of the conversation today. If you are coming to the Texas Democratic Convention next week in Dallas, which we are so excited for, the TDLA will have a panel, again, a CLE focused on redistricting, and on Friday at 10:30 a.m. and would love to see y'all there if you are coming to convention in person. And as you all know, the 2022 election is fast approaching, scarily enough, and we are going to need lawyers across the state to help make sure that Texans' right to vote is preserved. With the ongoing January 6th hearings, it could not be clearer that our democracy is really at a crossroads and in crisis, and that we need all of you and all of your legal skills coming to bear to support voters and help make sure that folks can vote. So I have all of your information, and we'll be sharing more opportunities with you starting in the next couple of weeks about ways to help voters remotely from your home, at polling places in your community, and many, many more. Lastly, the Texas Democratic Lawyers Association is going to be having our first annual Sissy Farrant Hold a reception and awarding of the Sissy Farenthold Award for Social Justice on Thursday, September 29th in Houston. More details to come will be in your inbox, but please save the evening of September 29th, as we would love to see many of y'all there and joining us for this first annual Texas Democratic Lawyers Committee event that will benefit the voter protection work of the state party and make sure that we can help preserve voting rights. So looking forward to all these things and many, many more with y'all as we engage the legal community in the important issues and controversies of our time. So I want to turn it over now to Barbara Radnofsky, one of the founders of the Texas Democratic Lawyers Association, who's going to kick off the CLE in the conversation.
Thank you. Thanks very much, Rose. Welcome, everyone, especially some very new potential members from Athens, Texas, who, thanks to Professor Berman, contacted me this morning. We are very honored to have Professor Berman here, and she's going to be taking your questions after a broad overview that is based on more comments than I've ever seen before a CLE program that we've had. It's very gratifying to see the tons of comments we've received, the memos you've given me, the briefs you've sent, the questions you've asked, and Professor Berman has received anything that I've gotten, she has in terms of questions. Let me tell you a little bit about Emily Berman. She's been on the faculty at the University of Houston Law Center for 7 years, where she teaches national security law, foreign affairs law, and most relevant for today, constitutional law. Every spring, she teaches as a virtual visiting professor at Washington University, St. Louis School of Law. Prior to coming here to Houston, she taught for 2 years at Brooklyn Law School and served for 4 years as counsel at the Brennan Center for Justice at NYU School of Law. After earning her JD from NYU in 2005, Professor Berman earned an LLM in international law and spent a year as a law clerk to the Honorable John M. Walker Jr. of the Second Circuit Court of Appeals. Her scholarly work has been published in top journals such as Iowa Law Review, the BU Law Review, the Minnesota Law Review, Indiana Law Journal, and NYU University Law Review. And I've read her opinion pieces in Just Security, The Atlantic Online, National Law Journal, Legal Times Online, and CNN. She's frequently quoted in local and national media regarding issues of constitutional law and national security law. But folks, it's her brilliant notes on the Dobbs decision, which appeared as a special feature in the in the Houston Chronicle right after Dobbs came down, which is amazing. She has annotated every key element of the decisions in a way to make it understandable to real people. We have given Professor Berman, as I said, the very many questions you've got, and we thought it would be best if we'd give her time to kind of give us an overview, please, Professor Berman, and then Carly and I are going to monitor the chat for more questions. And for those of you who just feel the need to text me, as sometimes occurs, I'll try to keep monitoring it through the texts as well. With that, please welcome Professor Emily Berman.
Hi, everyone. Thanks so much, Barbara, for the warm welcome. Thanks to the Harris County and Texas Democratic Lawyers Association for organizing the event, and to all of you for your interest and for attending. So, as I'm sure you know, there is so very much to say about this subject, and there's no way to get to all of it in an hour or in a month, for that matter. So here's what I thought I would do. I'm sort of assuming that most of you are generally familiar with what the opinions say, and what really brings us all together and interests us most is sort of the implications going forward. So I thought that I'd identify the 4 or 5 categories of things that I take away from this set of opinions and give you sort of my top line thoughts about them, just to set the table for some of the directions that the conversation could go. And just judging from the questions that that have been passed along to me, I think a lot of you are also thinking along similar lines. So I'm going to try to be as brief as possible, speak for maybe 15-ish minutes, but save lots of time for Q&A because I know there are lots of questions and really we'll all get a lot more out of this if we make it interactive. So I'm looking forward to the discussion. So first, let me just identify the sort of 5 categories of thoughts that I've had, for lack of a better word, on these opinions. So I think they sort of operate in sort of concentric circles. So at the heart of it are the immediate impacts on both the law and just the facts on the ground. And there are obviously very important implications in that regard in Texas and across the country. I think the next level of questions is what comes next for other substantive due process rights? Now that the court has overruled Roe and Casey, what does that mean for things like gay rights, the right to birth control, and other things in that similar line of cases? Next, I think there are questions about what larger shifts in constitutional doctrine does this case represent? Some of them I think are echoed in other constitutional cases from this term, things related to the role of history and stare decisis, and things along those lines. Then fourth, I think there are the sort of much larger questions about the role of the courts, and particularly the Supreme Court, and the sort of health of the current state of the rule of law in the country, the legitimacy of the courts, and potential for court reform. And then finally, what is there to do about any of the above questions? And so that's where I'll sort of end, hopefully on a slightly cheerier note than much of my other comments will be. So first, so the immediate impact of the decision, I think the first impact we see is chaos, right? So there's a lot of uncertainty with respect to the law, both as it exists currently and with respect to what is going to be permissible going forward. We know that states are going to be free to regulate abortion in just about any way and for just about any reason that they want to. Justice Alito's majority opinion articulated an incredibly deferential version of rational basis review that's going to apply to abortion restrictions. But things along the edges, like medication abortions, limits on travel for abortions, limits on helping people travel for abortions, what companies can do to help their employees access reproductive health care. Questions like those, I think we can expect to see litigation on all of those issues in the coming years. Some of it has already begun, but because of the uncertainty and because of the breadth of the laws that are in place or that are imminently impending, like SB 8, like the Texas trigger law that will ban all abortions from fertilization, like the law from 1925 that the Texas Supreme Court recently sort of reinstated, the immediate impact on the ground has been an incredibly chilling one for access to abortion. Nobody's performing abortions in Texas. Some clinics around the country are instructing patients that even if they're using medication for abortions, they have to be sure to take all doses of that medication in states that permit abortions because the clinics themselves are concerned about legal liability. Meanwhile, other states are setting themselves up as abortion sanctuaries and promising not to extradite healthcare providers who might provide abortions to out-of-state residents. So, if Justice Alito and Justice Kavanaugh, as they seem to imply, thought that they were sort of ending the national turmoil regarding abortion by returning the question to the states, they have another thing coming. And I think it's just going to be a new set of issues that form the sort of legal and political backdrop over reproductive rights access. So when it comes to due process rights more broadly, I think now famously that the Alito majority opinion said that liberty, as protected by the 14th Amendment, only applies to rights that are deeply rooted in this nation's history and tradition. Now, the majority is conspicuously silent on cases, most of them written by Justice Kennedy, who argued that fundamental rights, when you're looking to determine whether something's a fundamental right and what is the meaning of liberty in the Due Process Clause, that history is the starting point for that inquiry, but it's not the ending point. And as he said, we don't always recognize injustice in our own time. And if we hold ourselves to the rights that were historically recognized, then we're going to be stuck in a country that recognizes the rights that white landowning men were willing to recognize and nothing beyond that. And so in cases like Lawrence affirming the right to same-sex intimacy and Obergefell affirming the right to marriage equality, Justice Kennedy pointed out the importance that our definition of liberty needs to be able to evolve. And the majority simply ignores all of that jurisprudence, which I find particularly ominous, even though the majority went to great pains to try to distinguish those other due process rights from the right to abortion, pointing out that abortion had implications for, quote, potential life in ways that those others do not. And while that may be the case, it's not clear to me why the aspect of potential life that's in play in abortion should make any difference as a legal matter. If the important inquiry is whether the protection is deeply rooted in the nation's history and tradition, things like birth control and same-sex marriage are going to fail that test, at least in the same way that abortion rights have done. And so I'm not sure why, even though they profess to not be reaching those rights, I'm not sure why their legal rationale wouldn't reach them nonetheless. And I really can't say it better than Justice Kagan did in the dissent. I'm assuming it was Justice Kagan. It sounds very much like Justice Kagan, where she said one of two things must be true. Either the majority does not really believe in its own reasoning, or if it does, all rights that have no history stretching back to the mid-19th century are insecure. Either the mass of the majority's opinion is hypocrisy, or additional constitutional rights are under threat. It is one or the other. So I feel similarly about Justice Kavanaugh's concurrence, who also tried to provide some reassurance about other substantive due process rights. But just because he is acknowledging that those issues aren't raised in this particular case, that doesn't mean those rights are safe. And as we see in Justice Thomas's concurrence, he sort of makes that part explicit, right? He comes straight out and says, we should just eliminate the area of law entirely of substantive due process. And while he's not, this is not a new position for him, and he is writing alone, we don't know that he's alone in his thinking. And so what his opinion has done is invited litigants to challenge substantive due process rights that they don't like, and we'll see how many votes he can get. So I think we're likely to see not only challenges to existing substantive due process rights, but I also suspect we're going to start to see arguments that part of the life protected in the Due Process Clause of the 14th Amendment is fetal life. So it might go beyond simply eliminating existing rights and leaving them to the states to decide, to actually making abortion constitutionally barred nationally. I don't think that's right around the corner, but I do think it is the end game for some, at least in the anti-abortion movement. So So what about the larger shifts in constitutional doctrine? So I think the very clear winner in this regard is sort of the primacy of history. The court has said that not just in the Dobbs case, but also in their free exercise jurisprudence and the gun rights case this year, that history is the be all and end all of rights. And if the recognition of particular rights are rooted in history, we're going to recognize them. And if they're not, we're not. But as many people have pointed out, and as historians pointed out, even in the wake of the Heller decision in 2008, recognizing the individual right to bear arms, judges just aren't that good at history, right? They purport to engage in a comprehensive historical overview of whatever the regulation at issue may be, whether it's abortion regulations or gun restrictions. And it's just not clear that they are, first, it's not clear that they're not looking with an eye toward their desired outcome, right? So you can always cherry pick various aspects of history and decide what to place emphasis on and what not to. But even if they're doing sort of sincerely looking for what history indicates, that is something that professional historians train for years and years and years. And while the majority sort of gives us a tour through the historical eras dating back to the 13th century, any one of those individual eras might occupy the entirety of a professional historian's career, and they still might come out the end recognizing that they're unanswered questions. So I think the sort of important point to continue to strike in the wake of all of these decisions is that history is not an objective source of information. It, like law, has to be interpreted, and neither the justices nor their clerks, and much less lower court judges or their clerks or litigants at the trial level, none of them is trained historians, and their efforts as amateur historians have always fallen flat in retrospect when actual historians go back and look at what they've done. So we're liable to see more reliance on history, and yet while that is supposed to be a constraining force on judicial interpretation, I think it can have the opposite effect. And while they sort of can give lip service to the fact we're constrained by history, really, they can make history say whatever they want history to say. I think another big question doctrinally is the role of stare decisis and what extent this court values precedent. Here, at least, they admitted they were overruling Roe and Casey, and they went through an explicit analysis of why it was appropriate to overrule them here. But in other cases, they've sort of overruled past cases or past doctrines without admitting that that's what they were doing. So, for example, in the case about the coach who wanted to pray on the 50-yard line after football games, they didn't even say in that case the Lemon test, which has historically been used for Establishment Clause challenges and has come under a great deal of criticism from the court and commentators. They didn't say, well, the Lemon test has proved unworkable and therefore we're overruling it. Instead, Justice Gorsuch says, oh, well, the Lemon test, we abandoned that a long time ago. So I don't even know why the litigants below are relying on that outdated doctrine. So I guess it's outdated now, but prior to this case, the court hadn't explicitly overruled it. And yet, because it had been subject to criticism, and for that proposition, the court largely cites to their own either dissents or concurrences making that argument. Now, all of a sudden, they can simply argue that, oh, everyone should have known that it's been disregarded. And I can see that happening in other areas of law where the court doesn't like particularly the precedents that it is stuck with. And then the last doctrinal issue in Dobbs that I've also seen in other cases this term is the rejection of balancing tests. So normally in constitutional law, you ask, is there a constitutional right? And if it's being infringed, does the state's interest justify that infringement? And you balance the state's interest against the constitutional right. Well, in Dobbs, in Bruin, in the free exercise cases, they didn't do that. They simply said you ask whether the right is rooted in history, and if it is, that's the end of the inquiry. And that concerns me for things like what happens when free exercise of religion comes up against laws barring discrimination on the basis of sexual orientation, for example. So a couple of years ago, the question came up in the context of a baker in Colorado who didn't want to bake a cake for a same-sex wedding, arguing that that was against his religious beliefs. And in that case, the court sort of dodged the question, but the question doesn't go away just because the court refused to answer it a couple of terms ago. And I think one thing we've seen from this court is that they're perfectly happy to answer hard questions, whether they're presented to them or not. Which brings me to sort of my last point about the courts, which is the questions about the court's legitimacy and the rule of law. I think it's really hard to overstate the magnitude of the shift in constitutional law that emerged from this term. The last week and a half of the term, there were 4 or 5 opinions that in any other year would have dominated the headlines for days. And here they kept getting kicked out of the headlines by the opinions that were released the next day. And maybe that was the plan. But what we see is a very conservative, very aggressive 5 or 6 justice majority, depending on the issue and how you count, that's really out there just going down the road they want to go down without consideration of what that might mean for the court as an institution. And I think we see the court's approval is currently at an all-time low, almost as low as Congress, and that's saying something. Usually it doesn't, the court being out of step with the general public doesn't last long. Excuse me. And most famously, this happened in the New Deal, where the court was striking down FDR's policies trying to fight the Great Depression. The court kept striking them down. President threatened to add justices to the court, and sort of miraculously, the court switched over to supporting FDR's policies. And so that is that's a typical evolution of jurisprudence where the court might get a little bit ahead of or a little bit behind the country on particular issues, but over time they sort of come together. And that might happen here, but I'm worried about it because in cases like in 1936, when this happened during the Great Depression, there was a significant majority, both in Congress and in the public, and having re-elected FDR in a landslide, it was very clear that the Democratic forces were all pushing in one particular direction. Whereas here, I think we're much more evenly divided as a country on these issues. And so there just isn't the overwhelming opposition to what the court is doing yet. And I think the extent to which the court's perceived legitimacy either recovers or continues to fall is going to depend on the extent to which they're willing to continue to be this disruptive this quickly on issues where even the sort of conservative blocks of US voters aren't on board. So with abortion, they've gone much further than voters, than even Republican voters would go. Similarly, with gun rights, there's much more support for gun regulations than the court seems willing to allow. So even people who support conservative policies might ultimately balk at a court that looks more like a reactionary legislature. So I think there's a limit to how far they can go, and whether they're willing to acknowledge that limit or not, we'll see. So what is there to do about any of the above? So first, I would say to those of you who are particularly focused on the current emergency in reproductive health care, there are lots of organizations out there doing all sorts of work under horrible and difficult and uncertain conditions, and lots of resources to go to support that work. But I think sort of from a broader perspective, Dobbs is not the end of this discussion, right? In some ways, it's the beginning, and reproductive rights activists aren't about to give up any more than anti-abortion activists did in the wake of Roe. And so there's a lot that can be done through political activism and organizing and voting. I think people now see just how important voting in state legislative races and state judicial races are going to be. There are also people at work on alternative legal theories that would either provide support in the Constitution for a right to reproductive health care or to other substantive due process rights. So whether that be further developing substantive due process as an autonomy protection rather than as a privacy protection, using state constitutional provisions, arguing about things like abortion as an equal protection right rather than a due process right. There are challenges to certain abortion laws being brought under the Establishment Clause, saying that the concept of life beginning at the moment of fertilization is a tenet of a particular religious group, and that should not be imposed on our fellow citizens. There's arguments under the 13th Amendment and the ties that reproductive independence and autonomy have with the abolition of slavery, and some really great feminist historians that have done a lot of work in that area. So the bottom line is, I think, I wish there was a silver bullet. I don't think that there is, but I think there's a lot of work to be done on a lot of different fronts. And I think Dobbs, while it sort of set us back on our heels, maybe initially, I think Dobbs is just going to inspire more work in that regard going forward. And so, as I said, I don't think Dobbs is the end of the conversation. I think it's the beginning. And the fact that so many people are interested in this particular event, I think, is evidence of that. So I think I will stop there and see if I can clear my throat and let Barbara start taking some questions. So definitely, if you have questions, put them in the chat.
Well, thank you very much. The single greatest source of questions that I had came from lawyers, and perhaps many of us are trial lawyers and not appellate judges or appellate lawyers, but there's plenty of appellate lawyers on the line. And what I want to ask is really, I've received many questions about this, and that is not only how can we respect a Supreme Court that will misstate and ignore what some could argue are just interpretations of history, but misstate and ignore at least the facts of the case, or at least the findings of, for example, in the Ninth Circuit, the findings of the Ninth Circuit below. And we can thank Hank Jones and a number of his colleagues that, sent me the stuff to read about the charts in the Kennedy case on the, what were the facts below in a beautiful chart created by the Ninth Circuit. But there's many examples of that. Most telling, I think, is the anger at the historians of the world who wrote a wonderful amicus brief, and we'll put it into the chat. And it resulted in nothing. It resulted in ignorance, and it was available. It was already there and addressed specifically the leaked Alito issues. It anticipated those really, and then grew on it. And some of the footnotes which remain from Alito. And so let me read to you what the Organization of American Historians and the American Historical Association had to say. They said that they are the flagship organization of professional historians, along with 8 other historical associations who filed their joint statement, as well as amicus briefs. And they said that the majority decision that overturned Roe ignored the actual history. I mean, they're talking about it not as some interpretation, that it is rather agreed by historians, and instead, quote, adopted a flawed interpretation of abortion criminalization that has been pressed by anti-abortion advocates for more than 30 years. And the decision mentions history 67 times, that's what they note, but it ignored long legal traditions extending from the common law to the mid-1800s. And then they go in depth as to what happens in the states, even far longer histories. And they say they are ignoring the facts of history. There are certain facts of history. And another thing we can put into the chat would be the historian who wrote the wonderful New York Times essay, Goodwin, Ms. Goodwin, who talked about chattel slavery and its purposes. And there is no question in not only her minds, but the consensus of history at this point, of historians who actually do it as a profession, that the purpose of the Civil War amendments was to eliminate, a slavery process that was terrible and used human beings, women, as breeding livestock. And the children are born and sold. So it's frustrating for even lawyers who are supposed to understand these supposed concepts to see this case as anything but willful disregard of history and absolute bastardization of the facts to political ends. Now, just to get your reaction to that.
Yeah, I mean, it is incredibly frustrating. The historians came out and said basically Roe got the history right, and this now purports to talk about how egregiously wrong Roe was, and yet this is the case in which the history is mischaracterized. And I think so. One of my favorite. I just dug up this quote it's actually from Justice Breyer's dissent in the gun case, but I think that it is applicable to any of these historical analyses where he's pointing to the arguments that New York made in defense of their firearms restriction and pointing to historical firearms restrictions that would support recognizing New York's right to regulate guns in the way that they did. And so Justice Breyer says, some of the laws that the state identified are too old. Others are too recent. Others don't last long enough. Some applied to too few people. Some were enacted for the wrong reasons. Some may have been based on a constitutional rationale that's now impossible to justify. Some arose in historically unique circumstances. Some are not sufficiently analogous. And so he goes through all these reasons that the court dismisses history that's inconvenient to them in favor of embracing their own view of what history actually shows. And I think that, and as you point out, the history in the Dobbs case and the mischaracterization of the facts below and the case about prayer on the football field, which if you haven't read it, I urge you to look at Justice Sotomayor's dissent, where she includes photographs of some of the quiet prayers of the coach alone with his thoughts while the players are otherwise occupied, which is just a laughable description of what was happening. But I think all of those is part and parcel of this court saying, we have the vote, and this is what we want the law to be. And we're not going to let the facts get in the way of our ideology. And I think, just as the dissent in Dobbs points out at the end, the justices in Casey may not have agreed originally with Roe, the justices that upheld the fundamental holding of Roe in Casey. They may, as an original matter, may not have decided the same way as Casey, but they recognized that to overrule Roe for no reason other than a change in court's membership would do lasting injury to this court. And she points to them, Justice Souter, Justice O'Connor, Justice Kennedy, these are not the ideological purists that people today might look for in Supreme Court justices, but they were concerned about the institution of the court and of leaving the court better off than they found it. And those justices did that. Whereas here, he said, those justices in the Casey plurality said the American public, they thought, should never conclude its constitutional protections hung by a thread, and that a new majority could, by dint of numbers alone, expunge their rights. It is hard, no, it is impossible to conclude that anything else has happened here. And so I think, those are strong words for dissenting justices to level at their colleagues. And I think that is indicative of the alarm with which the Democratic appointees are viewing what's going on. Like, in all of their dissents, it's not only saying we think the majority is wrong, but they're saying we worry about where the majority is going next, and we worry about what this is doing to the court. And I think, there's no doubt that the court, they went to great pains in Dobbs to talk about how they should ignore what people think, what the reaction is going to be to their views. And it's clear that they aren't taking that into account at all. And they really had quite a great deal of disdain for Justice Roberts' opinion in Dobbs, where he was trying to take a more measured approach. And so again, I just think this court, they can do it, and so they are doing it.
And let's talk a little more about the specifics of Casey and bodily autonomy versus privacy rights, because a lot of these questions are raised by Justice Jerry Zimmerer, who has written and spoken for years about the physician-patient relationship, body autonomy, right to control one's own medical decision-making, the exercise of decision-making in medical futility cases, those kinds of things, which have broad implications. And that how this decision, and what I would point out in the dissent, and pretty early on in the teens, is talking about Kavanaugh's decision to talk about a variety of things, but to not address the impact of autonomy and any person's right, in their language, bodily integrity and family life. And it cites heavily on, of course, Casey, now overruled, without really much analysis by anyone other than the dissent. And then they disagree with, they go on to disagree at the end of this section by by really going after Kavanaugh's decision by saying, you're assuming that we're being neutral. This court is not being neutral. This court has made a decision to deprive us of an existing, I think they may even use fundamental right. Again, they're citing Casey, and it's on a very broad basis. And now every state can decide whether or not to deprive its citizens of that right. and that it is not a neutral decision. And so Kavanaugh, for all of his attempts to perhaps appear somewhat above the fray, just dumps people into it. I mean, I know that's not very lawyerly sounding. But...
Well, there is no neutral position here, right? I mean, so one of the things about the court is, if everyone thinks back to their first year in law school and constitutional law, when you talk about the counter-majoritarian difficulty, and this is the theory that says it's a little bit odd that the least democratic institution in our government has the final word in saying whether the majority gets their way or not. And the reason that's there is because if you can think of the Constitution as a pre-commitment device, saying we think these things are so important that we're just going to take them out of the area of political contestation because we don't trust ourselves in the heat of the moment not to step past the line that we today think is important. And so the whole point of the court is to decide things that shouldn't be given to the states, that shouldn't be given to the Congress, because they're too fundamental to be left to the vicissitudes of politics. And that's really what the court is there for when it comes to individual rights. And so by saying we are neutral, what you're doing is you're rejecting the existence of a fundamental right. You either have to accept it or reject it. And you couldn't say we're going to be neutral on equal protection, and the states are going to decide whether or not restaurants can serve African American people. That's not how constitutional rights work. So I think that is really sort of a red herring that Justice Kavanaugh raises, and he's a very smart guy. He knows very well what he's doing there. As far as the source of that right, you can argue about where in the Constitution you think reproductive autonomy should be located. Should it be a liberty right? Should it be an equality right? Should it be a Ninth Amendment right, which says just because we said all of these things and made this list in rights 1 through 8, that doesn't mean there aren't others that we haven't mentioned. And of course, the Ninth Amendment has never really been recognized to protect anything in particular. So you could make lots of different arguments about where that right exists. And if you look at the various opinions in Griswold establishing the right to contraception, that's exactly what the court did there. Is there were several theories about where might this right to contraception exist. But if you look at not just the Griswold case and the cases that came after it, like Roe and Casey and Lawrence, but also the ones that came before about, do you have the right to teach your children German, even though we're fighting in a world war against them? Do you have the right to homeschool your children? There's this thread through all of these cases about your liberty interest in family matters. And one label the court has given that is privacy, but another way to describe it is there's a realm of your personal family life that you are entitled to decide what happens. And the later we get in the abortion jurisprudence, sort of the more that autonomy right and the decision whether to bear or beget a child sounds much more in the autonomy and the dignity of individuals, as opposed to what we might think of as a more traditional privacy right. So I think you could make a separate doctrinal argument about that, and the dissent goes through some of this. And as you said, the right to refuse medical treatment is very much in that line. The right not to be involuntarily sterilized is another right in that line. The problem is you could come up with the greatest constitutional argument in history, and I just don't think it's going to matter to this court what you say. So yes, that's one way to argue about the abortion rights. It may also be a way to preserve some of the existing substantive due process rights, to say, like, we should rest it on a theory of autonomy rather than privacy. But when it comes to abortion rights, I don't think the theory is going to make a difference.
There's a question. Let's go to the questions in the chat. We've got a comment that, could a state prohibit one of its inhabitants providing funds for a woman to obtain an abortion in another state? Do you agree with Justice Kavanaugh's assurances that travel to obtain an abortion elsewhere cannot constitutionally be infringed?
Well, I appreciate that that's his view. I think that's one justice's view, and I don't think it tells us anything about what the others think. And I think there are two questions there. So one question is, can you prevent someone from traveling to get an abortion? And that might come up against the right to interstate travel, and so maybe that's something that the state can't do. I think it's a separate question whether you can assist someone in traveling to another state by, for example, funding their travel. And if you look at, it's one of the issues with the Texas abortion laws, is if you look at them, they explicitly address people who provide assistance, and assistance in the form of money, to someone to procure an abortion. And it opens you up to liability under SB 8 at the very least. And so there are, I know, organizations that this is what they do, who have ceased to operate in states like Texas, where abortion is illegal, because of their concern over their legal liability. So I think it goes back to sort of the uncertainty surrounding a lot of these laws, and the effect of uncertainty is that there's a risk aversion among abortion providers and people that might want to help people access abortion, in the face of this uncertainty, that they're going to be either civilly or criminally held liable. So I suspect we'll start getting some cases where people ask for declaratory judgments that they can or cannot do something, and the lines will hopefully begin to become more clear. But right now, under Texas law, I think if you give someone money to go out of state to get an abortion, I think you can be sued by your neighbor for $10,000.
There's a number of questions about religion in the chat, and that I've gotten a text on too. Do you have any thoughts on what the court would do with the Florida case about Jewish religion and the fact that it's not the same as the Catholic religion?
Yeah. So for those who aren't familiar, there's a case in Florida that is a challenge to the Florida law banning abortion. And basically what it says is, under Jewish law, if pregnancy is posing a threat to the woman's mental or physical health, then there is an obligation to end the pregnancy under Jewish law. That's the claim. And so the law is saying, as a matter of free exercise, we have to have the opportunity to make this decision. And I think it's a great litigation strategy, in that it's sort of asking the court, are you going to put your money where your mouth is? And does free exercise mean free exercise for Christian evangelicals, but not for everyone else? Or does free exercise mean free exercise? There was this is getting like a little inside baseball in legal academia, but there's a popular blog called the Volokh Conspiracy that's run by Eugene Volokh, who's sort of a conservative scholar. And someone wrote a blog post on that website saying, essentially, Jewish law doesn't really require this, and therefore this should be thrown out as a faux invocation of religious exercise. So it's sort of inviting the court to decide what's sincere religious exercise and what isn't, which is something that the court has always stayed away from and has always sort of assumed for the purposes of cases that if you assert that you're acting because your religion requires it, we're going to believe you in that regard. So we'll see if the court is more willing to inquire into what religions actually hold, what rules they actually impose on their adherents, or if the court is going to find a way to uphold Christian values but not non-Christian values. And so I think those are the kinds of arguments that people are going to have to start making, based in history, based in free exercise, because those seem to be the rights that the courts are willing to acknowledge. So obviously time will tell if it's going to be successful.
We've got more questions. This one about Native American law. And the question is, can that supersede what the individual state says? And if you would lump in there some of the proposals that would involve use of federal land for some sort of solution.
Yeah, so that was one proposal, was that the government, or the federal government, or Native American governments could make facilities available on their territory for abortion providers to operate out of. And the federal government couldn't fund those because the law doesn't permit that, but it could make facilities available, allow a clinic to operate on its territory. And the same has been said for Native American lands. The court's most recent decision about Native American law, I think, might pose a problem there, because what they found in that case was that the state of Oklahoma had concurrent jurisdiction to prosecute a non-Indian for a crime against an Indian. Indians were the statutes used. So, but anyway, a non-Native American against a Native American on Native American territory. And that had historically been assumed not to be true, that that the Indian tribes had jurisdiction over their territories. Now, and I haven't read this case in as great a detail, and I don't know this area of law as well as I know what the rest of what we've been talking about, but I suspect that law now opens up prosecutions under state law for things that take place at least by non-Native providers on Native American territory.
Do you think they had it in mind when they made their decision? Do you think they had the future in mind, specifically regarding abortions, when they made such a extreme, I believe, extreme change from the earlier, not that long ago, decisions, the decision about giving Native Americans their due in terms of tribal lands?
Yeah, I wouldn't be surprised at all if that were the case.
Okay.
I say that based on pure speculation, but
well, we're interested in your opinions.
Whatever we think about these judges' jurisprudence, they're not dummies.
Right. Well, there's a question. Somebody texted me. Where are we headed in the fall term? what do you think of the acceptance of the case involving the independent state ledge theory? And that it's longer, but it's all about where are we headed in the fall term, and they're worried genuinely about gutting the civil rights of pregnant people, and now we're going to go start overturning federal elections.
Yeah, so the fall is also, they've already taken some really significant cases. So they're going to decide on the constitutionality of affirmative action in higher education. So I think we can kiss that goodbye. They are looking at a case where it's a conflict between the free speech rights of someone who is anti-LGBTQ, the conflict of their free speech rights with non-discrimination laws. So that could set up, free exercise claims as sort of a trump to anti-discrimination laws around the nation. And then they took this independent state legislature doctrine, which, there are various incarnations that could take it to various extremes, but it does raise the possibility that neither state courts nor state governors can veto any laws that the state legislature makes about conducting their elections. And so, for states that have Republican legislatures and Democratic governors, it's a potential way for them to really get around the checks that would be imposed by either courts or Democratic governors on the way that they want to carry out elections. So I think it's part and parcel of the trend in not just changing the laws, but changing the mechanics of government in a way that entrenches the current, what is sort of a minority view through mechanisms that just make it harder for true majoritarian positions to win out, whether it be in state or federal legislatures. So the next term, and this is just, they haven't even finished picking for the term. So that could be a big one too.
Well, we usually stop at 1:05, and I would love to get your conclusions. You said you kind of promised us a little hope, and so if you could kind of leave us on your wisdom and ideas, it would be much appreciated.
Yeah, so I've struggled to be hopeful since these cases came down, and I think where I've landed is that this was a traumatic event. I think we should give ourselves permission to be distraught and troubled by it, and we're sort of still recovering, and at least for my part, still a little bit in shock. But I do think there are a couple potential bright spots. So first is that this court is far to the right of where the average American voter is. And so I think it is possible for the court and for Republican legislatures that are playing to their bases to go too far and to overplay their hand, and at some point face some backlash on the extreme positions that they have been taken. So I think that's one, is we can look down the road and see a lot of dominoes falling, but it's possible that whether it's the politicians who are implementing these rules or the court that's making decisions might decide that, there's sort of a bridge too far that they're not willing to go. But also, I think that, like I said before, there are a lot of smart people who are devoting themselves to coming up with legal and political strategies to implement going forward. It's not something that's going to happen overnight. I tell my students at the end of every spring semester in constitutional law that if anything should be clear after a year or a semester of studying constitutional law is that the meaning of the Constitution is never fixed. It is constantly evolving, and every generation sort of decides what the Constitution is going to mean for it. And so if you care about what the Constitution means, don't sit on the sidelines, be part of that conversation, I tell them. And I really can't think of a more effective call to arms for progressives in arguing about what we want the Constitution to mean for us than the Dobbs opinion. And I expect it to have a galvanizing effect, much in the way that the election of Donald Trump did, and that those of us who choose to fight these battles are not going to be alone. And so I think we have to think of it as sort of a long game, in the sense that, like I said, it won't happen overnight, but we're also not helpless. And taking action, however small, can often help from not feeling helpless. And so I urge people to do what they can in that regard. And like I said, I think there'll be a lot of people right next to you doing the same thing.
Well, we very much appreciate you being here. It is a comfort. And on September 1st, we're going to have Professor Ray Perryman, economist Ray Perryman, speak on how these issues intersect, the various actions of various states and markets approach, corporations, the corporatocracy, if you will, how that is influencing law, how that is influencing judicial decisions, and whether or not the power of the federal government is being greatly eclipsed, not just by states or state legislators making decisions that previously would have been considered federal, but also how corporations and moneyed interests are dominating much more than we've thought before, and where we are headed for the future. And we of course would welcome you anytime. If there's time to look at the chat, I see there's some folks who would like to hear from you more too, including some folks from up in the Dallas area, SMU. So
okay.
You've got lots of thanks and I've got a bunch of texts that have been coming in. This has just been quite important for us. And so we thank you for letting us just call on you at the last minute as soon as we saw your paper in the Chronicle. So thank you.
Well, it's my pleasure. And my email is on the UH website. I can't promise to get back to you immediately, but
Okay.
But if you have questions that I didn't get to, feel free to send them along, and I'll try to get to them.
Okay, well, we promised Carly we'd be done before 1:15. And Carly, if you have any last minute goodbyes, thank you for placing all of that stuff in the chat. You were keeping up and finding old New York Times stuff and new briefs that we appreciate that.
Well, thank you both for hosting such a wonderful discussion. Everyone in the chat is replicating these thoughts of thanks, because it's very comforting to hear a voice of reason when the last few weeks have felt tumultuous, to say the least. So if you want to get involved in the next steps, contact us at the Harris County Democratic Lawyers Association from our website. I'll post the email in the chat, and we can connect you with individuals in the community that do work in keeping our country pro-choice. Additionally, once again, I'm going to plug the student organization, Democratic Law Student Association. If you know students at any law school in Texas that want to start their own chapter, please send them my way and we can get them linked in to start their own chapter and get involved with the Democratic Party. Other than that, thank you all for coming. Make sure you get the CLE credit number in the chat, and just reach out if you have any further questions.
And let me just give you, for those of you who have pens handy, here's the CLE number. It's 174-164-823. 174-164-823. Thank you, everybody. Thanks, Professor.
Thanks.